Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
And we are going to go ahead and get started. Thank you for joining us for Synergy's Third Thursday webinar. Today we will be focusing on ERISA liens. We will have a brief question and answer at the end of the presentation, so please do use the question box. If we aren't able to get to your question, we will make separate outreach to you shortly hereafter. The webinar itself will be added to our website and also sent out to all of the attendees tomorrow morning. And these presentation slides can be requested as well. Here is my bio slide. My name is Teresa Kenyon, and I am the Director of the Lien Resolution Department here at Synergy Settlement Services. I am a licensed attorney in both California and Kentucky. My team specializes in negotiating all sorts of medical liens, including ERISA, FEBA, Medicaid, Medicare, Medicare Advantage, TRICARE, and VA. We are such a collaborative team, and we've developed more and more insider knowledge through sharing our experiences. Prior to joining Synergy, I was on the other side. I was employed with the Rawlings Company for almost 8 years, representing the health insurance carrier's interests. So I'm now very happy to be on the other side. We call it the bright side. So I am able to assist the injured parties in retaining as much of their settlement proceeds as possible. Many members of my team similarly come from the very subrogation vendors that we negotiate with every day. Before we get started talking about ERISA liens, I wanted to take a quick look at the other services that we can provide for plaintiff attorneys and their clients here at Synergy. So today we are talking about healthcare lien resolution on settlement funds. Then we also specialize in Medicare compliance and offer a MECE, which is a Medicare expert case evaluation to ensure that you're compliant with all things related to Medicare's future interest on your client's settlement funds. We also have settlement planning and consulting as another focus. We can design a customized settlement plan for your client's settlement funds through traditional financial products and legal documents, including professional managed accounts, trust, and structured settlements. And this leaves your client with lifelong security and tax-free rates of return. For trusts, we have connections to assist with the management of a trust, ensuring that injured parties continue to qualify for need-based public benefits like Medicaid. And then finally, attorney fee deferral. It's an attorney fee structure that's pre-tax and tax deferred, and it's available for attorneys that earn contingent legal fees. And this is our agenda for today. While we talk about ERISA liens, we're going to start with what is ERISA and then have some discussion about self-funded versus fully insured plans. The whole idea of third-party liability provisions in a health plan, subrogation and reimbursement theories. We'll review the US Supreme Court decisions, at least 2 of them, and then talk about plan document requests so you can make sure you're looking at the right documents, and a brief discussion about how to read the Form 5500. And then we will conclude with question and answer. So let's get started with some basics about how ERISA originated. So ERISA stands for Employment Retirement Income Security Act, and the original intention at its 1974 creation was focused on pension plans and not health benefits, but it has evolved into really impacting both. So according to the U.S. Department of Labor, ERISA protects the interest of employee benefit plan participants and their beneficiaries. So we're off to a good start with ERISA protecting employee benefit plan participants. It requires plan sponsors to provide adequate plan information to participants. Adequate information is always appreciated. It establishes standards of conduct for plan managers and other fiduciaries, requiring that they meet certain standards of conduct derived from the common law of trust and applicable to all fiduciaries. That also sounds good. We want those plan managers to have some guidelines and to know what they're doing when it comes to the payment of medical expenses. It contains detailed provisions for reporting to the government and disclosure to participants. This is also good. The participants should always know what's going on with the benefits that they are receiving. It also establishes enforcement provisions to ensure that the plan funds are protected and that the qualifying participants receive their benefits. So that sounds great as well. We want the participants to receive their benefits. The health plan should pay for their medicals or for pension plans or whatever else might be captured here. So on the whole, this can all be interpreted as a great thing for the employee. The employee is protected. The plan has to follow rules. The plan has to provide detailed reporting to the federal government. It must provide disclosures to the participant and establish guidelines on things like how denied claims can be appealed. And it also ensures that the funds are protected and delivered in the best interests of the plan to pay these future claims. But that's not quite how it feels when you're on the receiving end of an ERISA plan asserting a lien against an injured party's settlement. So that's what we're going to talk about here today. So we've established that ERISA is meant to protect the employee and that it covers retirement plans and also health benefit plans. I've got a couple slides here with some data from the Department of Labor's annual report to Congress on self-insured group health plans. The Affordable Care Act required the Secretary of Labor to provide Congress with an annual report containing general information about self-insured employee health benefit plans and financial information regarding the employers that sponsor those plans. So this data comes from that report. It's estimated that there are approximately 2.3 million ERISA-covered group health plans. And those plans cover about 135 million workers and their beneficiaries. And this includes $7.6 trillion in assets. About 59–60% of America's workers earn health benefits through their employer. So how do you know, or how do you determine if the plan that provided benefits to your client is indeed ERISA? So the general question to ask is it an employer-sponsored plan? Because ERISA covers employer-sponsored health plans. There are some exceptions, though, including religious employers. Those are going to be subject to state law, and then also government employers. Those are going to be subject either to state or federal, depending upon which type of government it is. The City of Atlanta, the County of Orange, or the State of Texas are all going to be subject to state law, whereas a federal employee like an IRS worker or a postal worker would be covered under FEBA, which is a federal law. Government plans are not covered under ERISA, and those types of plans would include your Medicare, Medicaid, or military liens. And then finally, individual plans are not governed by ERISA. So those are plans that are purchased for just one person. Could be through the marketplace because of Obamacare or the Affordable Care Act, or perhaps someone that's self-employed who purchases through a health insurance broker. Those would not be subject to ERISA. And here is some additional data. These numbers were reported by the Department of Labor based on Form 5500 data. And so it's important to note that a health benefit plan is required to file a Form 5500 if they have 100 or more participants on the plan. Regardless of size or the number of participants on the plan must file a Form 5500 if they hold assets in a trust. Roughly 57,800 health plans filed Form 5500s in 2017. which was the earliest bit of data that I was able to receive. Of those, 23,500 indicated they were self-insured. And of those 23,500 plans, it captured 34 million participants, and there were assets of $95 billion. So we're going to focus here on those self-insured plans. So what is self-funded? We often hear people speak of ERISA plans, asking only if it's an ERISA lien, but they seem to stop there and not ask the most important question about the funding status. And the confusing part here is that you'll see all of the same players, the same insurance carriers involved, whether it's a self-funded plan or a fully insured plan. Insurance carriers like United, Aetna, WellPoint, Cigna, Highmark, HealthNet, Blue Cross, Blue Shield, Anthem, and the list goes on. But those carriers do work for both the self-funded plan and as a fully insured carrier. So what's the difference and why does it matter? So sponsors of self-funded plans generally pay their plan's covered health expenses directly as the plan participant goes to the provider and the provider submits claims. The employer likely collects premiums from the employee on each paycheck. The key to self-funded is that the employer then places those funds and their own contribution into an account that is to be used for solely paying the claims of those plan participants. The employer will likely pay an administration fee to United or Aetna or Blue Shield to administer the claims, but the actual payment for the medical claims themselves comes from that employer account or trust. In these cases, an employer may purchase stop-loss insurance, but unfortunately, as of now, this does not change the self-funded status of the plan. These plans, even with stop-loss coverage, still get full preemption under ERISA. Now, there is a little bit of an exception, is that if that attachment point for the stop-loss coverage is extremely low. But otherwise, these plans under ERISA, because they're self-funded, preempt state law. In contrast, sponsors of fully insured plans generally pay premiums to insurers, which in turn assume that financial responsibility of then paying the claims as they are submitted by the providers. But just like a self-funded plan, the employer will collect premiums from the employee, and the difference is where those funds go. So for that self-funded plan, they go into that employer-controlled trust account. But for a fully insured plan, they go directly to the insurance carrier as a premium for coverage. And for the fully insured plan, the employer has no financial responsibility for the medical claims themselves. These plans are subject to state law. So for your client, and even for you on its face, it's nearly impossible to tell the difference. The insurance card shows that the coverage is with United or Blue Cross. Those carriers are the experts in processing claims, and they are definitely present for both self-funded and fully insured plans, so you have to dig deeper to figure it out. And we'll talk about that here as we go forward. As I indicated earlier, ERISA's intent was to protect employees, but it just doesn't feel that way when you've got an ERISA self-funded health plan asserting a lien. Now, this particular case, and I've got a quote up here on the screen, it's an older case. It's from a district court, but this judge had it right on, and really the sentiment here continues even today. In this case, the issue was more about coverage under an ERISA plan, specifically related to the denial of authorizations for hospital stay for detox and for inpatient rehab that eventually resulted in the death of the plan beneficiary. So it's not at all related to a subrogation claim, but again, the sentiment is certainly transferable to what we see today. So the quote here, "This case becomes yet another illustration of the glaring need for Congress to amend ERISA to account for the changing realities of the modern healthcare system. Enacted to safeguard the interest of employees and their beneficiaries, ERISA has evolved into a shield of immunity that protects health insurers, utilization review providers, and other managed care entities from potential liability for the consequences of their wrongful denial of health benefits." A further line from this opinion provides that ERISA is a comprehensive statute designed to promote the interest of the employees and their beneficiaries in employee health benefit plans. It is therefore deeply troubling in the health insurance context that ERISA has evolved into a shield of immunity which thwarts the legitimate claims of the very people it was designed to protect. What went wrong? And that was straight from the opinion itself. So let's talk about subrogation, the recovery of settlement funds by one of these ERISA self-funded plans. This is our focus of where ERISA isn't protecting the employee, at least not the employee who's injured. The asserted idea is that it's protecting all of the participants of the plan, that a health plan shouldn't pay for medical expenses when someone else is at fault, and that the health plan should be able to retain those funds for everybody else. So subrogation itself's been around for a long time. From what I've read, it's got roots in Roman law, perhaps as far back as the 1st century. And at that time, it really was more focused on the replacement of one for another. And that sentiment still is present here. It's obviously developed quite a bit since then, but the idea is that one party can be substituted into the rights of another to collect their own damages. In health insurance subrogation, a concept likely originating only in the 20th century, it means that the health plan can step into the shoes of an injured party and present their own claim directly against the tortfeasor. Now, I've always struggled with the idea of stepping into the shoes of someone else. In this context, it shouldn't allow the health plan to knock the person with the original claim out of his or her own shoes in order for the health plan to then stand in them. But unfortunately, that's how these subrogation vendors see it. It's not that both the injured party and the health plan are standing side by side and looking to the tortfeasor equally, but rather the self-funded ERISA plans assume the shoes, present it as if their own damages are more important than the person who's actually physically injured. And really, it's absurd if you think about it. So here's a simplistic example of damages in theory. So Penny is rear-ended by Dale. Penny sustains injury. It's Dale's actions or his negligence in driving the vehicle that caused Penny's injury and therefore the need for her to have medical treatment. So logically, and the way this whole thing works is that Dale should pay for Penny's injuries. He should pay for her damages. So the story gets more complicated when a health benefit plan paid for those medical expenses. From their perspective, subrogation is an important concept, and they've got a few proclaimed purposes of subrogation that they find are very positive. So as seen in the previous slide, placing that financial burden on the actual wrongdoer makes some sense. I can agree with that idea, but with restrictions. Second reason why health insurance plans claim that subrogation is necessary is so that it prevents a double recovery. Health plans would claim that if the health plan paid for the medical damages of, say, $50,000, then the injured party is not actually out $50,000 for medical expenses. And they would be double collecting by receiving $50,000 as part of their settlement when it was actually paid for by somebody else, that health plan. Okay, it can make some logical sense, but the application requires analysis. It should not be a one-size-fits-all, dollar-for-dollar reimbursement for double damages. And unfortunately, that's what happens with these ERISA self-funded plans. As we know, the medical expenses are part of the overall damages, and it's usually the largest multiplier or the largest piece of the underlying damages that you then multiply to assess the total damages, including pain and suffering and other non-economic damages. A further purpose of subrogation from the perspective of the health carrier is that it keeps insurance premiums low by reimbursing the pot. It goes back to the purpose of ERISA to protect the plan participants. And this is where it can get twisted in the sense of we've got to make sure that we're taking this money and putting it back into that pot so that we can pay for all of the future claims that we see submitted to this plan. It's honestly a bit of a farce. I'm not sure how much money actually goes back into those self-funded accounts. I can tell you that the subrogation vendors take a nice piece of the pie for their collection work. It varies based on the individual subrogation contract that each vendor has with each insurance carrier that they do work with, but it can vary anywhere from 15% up to a full third of the check that you end up sending to reimburse a health plan. I also read some things recently that aside from the collection companies or internal subrogation departments that are receiving these funds, that a lot of these funds go to executive compensation or bonuses or things that it just never gets back to the actual pot. So this whole idea of this is what it does, who's overseeing that? But when you stop to think that you negotiated a $20,000 payment to reimburse an ERISA self-funded plan, and really, maybe about a third of that actually goes back to the self-funded plan, maybe zero. But it's infuriating to think, especially when you think that the participant has zero visibility on this. So what happened to ERISA requiring the plan to provide adequate disclosures to the plan participant? And who's overseeing this to make sure that the money is actually going back to where it's supposed to be going back to? So here's subrogation in reality. Let's assume that it's Penny's health insurance that paid $50,000 in medical expenses, and that Dale had insurance, and his insurance paid Penny $100,000. It's the policy limits. So the question is, should Penny's health insurance get back their $50,000? This is what these plans operate under. They believe that their damages are more important than the actual injury victim, that it's more important to reimburse a minuscule amount of money back to the health plan's account than to ensure that Penny is actually reimbursed for her injuries. This doesn't sound like it's protecting the employee. It's certainly not protecting Penny, the employee in this case. And we aren't sure if it's really protecting all the other employees because we don't know for sure where that $50,000 is going. Let's throw some further reality into the mix. So Penny had other damages. She was out of work for 4 months and lost $20,000 in wages. There's a hospital lien of $70,000 that wasn't paid for by her health plan for some reason. And then once she went back to work, she started with a new employer, and now she has a new health insurance plan that is also claiming that they are ERISA, and they've asserted a lien of $30,000 for the second surgery that she had to have as a result of this loss. And then Penny had to hire counsel to represent her because Dale's auto insurance carrier didn't agree to pay out right away. So Penny's incurred attorney's fees and cost. So should Penny's original health plan get their full $50,000 back? Well, the health plan believes so. They often think in a silo, and even though you present all of these other damages, they look back at their policy language and they proclaim that they're ERISA self-funded and that they have priority. So while some will realize that there are competing interests in limited settlement funds, most unfortunately believe that they're doing you a favor by offering you a small reduction of their $50,000 interest. The more competing interests that there are, the more complicated this whole lien resolution can get. And now it's getting really complicated. These are all kinds of what ifs, and these are the issues that you deal with every day. And we see it every day as well. And to us, every one of these questions matter. So what if Penny was partially at fault? And what if it really limited her ability to obtain all of the available limits? Or what if because she was partially at fault, she only received half of the available limits? What if Dale's insurance was limited to $50,000? Would the plan be entitled to it all? What if Penny was a minor? Is a minor responsible to the plan, or is it the parent? And what if Penny's counsel had to litigate for 7 years to get a result? And then what if the case is now fully upside down because the cost exceed the jury verdict? What if Penny's now unable to work? She's on disability and she can't pay her bills. What if Penny needs ongoing treatment? Is the plan going to continue to pay for the treatment? Will they want reimbursement for the future claims? What if she's permanently disabled, she's blind or disfigured, she has a scar across her face that she has to see in the mirror every day. Does it matter that she's severely impacted for the rest of her life? And then what if Penny died? Is her family responsible for this? Who owes the obligation to the health plan? Each one of these questions has a complicated answer. And the real answer is that it depends on the ERISA plan's contract. We'll talk about the case law shortly, but on ERISA self-funded plans, that contract has to be clearly written and clearly indicate their intentions. Otherwise, equitable principles apply. When we're talking about the recovery of the settlement funds for an ERISA self-funded lien, we're actually talking about two different legal theories, and it often gets confused even in case law. But there's reimbursement and then there's subrogation. And so often we just hear the umbrella of subrogation, and I've even done it myself throughout this presentation. But reimbursement is when the health carrier directs their attention to the injured party, to the beneficiary of the medical treatment, and that they do so after the injured party has collected the settlement funds from the liable party. So it's almost like they're in wait. They're waiting for the pot of money to come to fruition, and then they are seeking their reimbursement from it. On the other hand, you have subrogation, which is where the health plan or the health carrier is actually going directly to the tortfeasor. So as you're dealing with wrapping up the underlying case, most subrogation vendors for these health plans are subrogating. And that means that they're going directly to the insurance carriers that you're trying to settle the case with and trying to get full reimbursement of their asserted lien. Sometimes you don't even know that this is happening. Some insurance adjusters will tell the subrogation vendor representative to go pound sand and go get your reimbursement from the attorney. I'm not dealing with you, I'm dealing with the attorney only. But some insurance adjusters cave, and subrogation vendors can get aggressive, telling the insurance adjuster that they'll be on the hook even after settling the case because the health plan is not reimbursed directly. They'll demand that they get their name on the check alongside yours, or they'll demand a separate check. All of these things that can complicate the issues on your end. And really, there's nothing worse for a subrogation vendor representative than an insurance adjuster who won't even answer their questions about status and who certainly won't appease their right of a direct cause of action. Instead, that insurance adjuster tells them that they owe them no obligation and that they're not a party to their contract that gives them these so-called subrogation rights. In those cases, it's your office that's likely going to field more phone calls from these subrogation vendors asking for updates and trying to figure out when that settlement pot of money is available for them to seek their reimbursement. But at least in that case, you have more control as the handling attorney. A subrogating health plan can really mess up your case by interfering and providing claim summaries to the adjuster before the case is settled. And I mean, it really is an interference. And unfortunately, there's little to no case law that says that the health plan can even do this. But they believe that they can, and they do. There's definitely a huge push to do just this. Generally, subrogation started as a principle of equity. It was not meant to create an injustice to the injured party like it does today. So when you're talking about subrogation, going directly to the at-fault party, there's technically three legal theories that this falls under. So equitable, contractual, and statutory. Equitable subrogation applies as a matter of law, and it's based in equity. It's supposed to create fairness. So it's the whole idea that the wrongdoer, Dale, should not benefit because an injured party, Penny, had insurance to pay for her medical expenses. Unfortunately, in practice, the fact that an injured party had insurance can sometimes hurt them when you have an ERISA self-funded plan now knocking on the door to obtain most or all of the settlement. The idea that the injured party shouldn't recover twice for the same loss and receive a double recovery doesn't really apply when there's limited funds or there's other damages that aren't paid for by the health insurance carrier, as we saw in those previous examples. And no doubt, as you see on the regular in your practice, it's usually the injured party who's not receiving their fair share of a recovery. Instead, it's the insurance carrier who would have had to pay for these claims whether or not there was a settlement is obtaining a windfall. This is classic unfairness and inequity. But this equitable subrogation is what you'll see an ERISA lien holder asserting if there isn't a contract about subrogation or reimbursement. In theory, it's supposed to prevent the party from receiving a windfall, but it only works when equitable defenses are available to provide the limitations. And the good news is, in this situation, when there is not a contract and it's under equitable subrogation theory, the equitable defenses kick in. Now, meanwhile, there is not equitable reimbursement. And that's a tricky spot because if there is no contract, then there is no ability for them to come directly to the injured party to get money out of that settlement pot. Now let's flip over to contractual subrogation, because this is what you're going to see with most ERISA self-funded liens. They're going to have a contract. They have to have a contract under ERISA, and really their right is established by that contract. They update this policy language through the summary plan description, the SPD, on an annual basis in most situations. They also have a master plan document in most situations that you should be requesting. We'll talk about that here a little bit later. But otherwise, the contractual subrogation is considered an agreement between two parties, between your client and the self-funded plan, even though it's very obviously a contract of adhesion because it's one-sided. And what the case law has developed is that these contracts that are one-sided can eliminate any equitable doctrines. And then the third one is statutory subrogation. So that's going to be more of your Medicare, Medicaid, military, hospital liens, workers' compensation liens, things like that. Let's take a look at a couple of the U.S. Supreme Court decisions surrounding ERISA liens. This will be a very simplified overview. As you can imagine, a much more in-depth discussion could be had on each one, but I'm just going to focus on these two. So FMC Corporation case held that ERISA self-funded plans preempt state law, and particularly the state law that otherwise tries to limit the plans. And then the biggest one that you no doubt hear from the lien holders that you interact with is the US Airways versus McCutchen case. That case held that equitable theories like the made whole rule or common fund rule cannot override clear policy language. The key word here is clear. And unfortunately, an ERISA plan has the opportunity to update their language year over year and continue to be clear as certain obstacles are seen. We see plenty of policies where they think that it's clear, but it's really not. It's not as simple as stating that they have a right to be reimbursed. The whole point of McCutchen is that the words matter and that the words should be clearly stated. And we all know that classic contract law tells you that any ambiguity should be construed against the drafter, which is certainly not the injured party. So if you've been dealing with liens for any length of time, I'm sure that you've seen the McCutchen memo from the Rawlings Company. I imagine you've also had your fair share of lien holder representatives from all companies responding to your request for reduction by simply saying it's an ERISA self-funded plan and we must be reimbursed 100%. That's what they're trained to do. Unfortunately, what they haven't been trained to do is really dig deep on the policy language and assess whether or not it's as strongly worded as it could be. So this McCutchen memo was, and maybe it still is, sent out on every single ERISA self-funded lien. If it still is happening, then you may have received hundreds of these. But what's often lost on doing that is that the McCutchen case actually does help the plan participant when that language is not fully locked. The McCutchen case said that the ERISA plan's terms govern, but when it's not clear, that's a problem for the plan. So in the McCutchen case, the US Airways policy did not clearly disavow an attorney fee reduction, so it had to provide one, as equitable principles will fill those gaps, those places where it's silent in the policy language. And this is a line from the US Airways versus McCutchen case from the US Supreme Court, and it definitely reflects the equitable theory that the plaintiff's bar is looking to have confirmed. I generally include it in every presentation that I do because it's very true when talking about how a health plan even has the possibility of getting any funds back in these situations. So the quote is, "The rationale for the common fund rule reinforces the conclusion that the third party's recoveries do not often come free. To get one, an insured must incur lawyers' fees and expenses. Without cost sharing, the insurer free rides on its beneficiaries' efforts, taking the fruits while contributing nothing to the labor." And as I indicated before, in the McCutchen case, the plan was silent as to a reduction for attorney's fees, so the common fund doctrine was an appropriate default rule to fill that gap. Now remember that one of the original intents of ERISA was that these ERISA plans are required to disclose to the plan participant. And so what came out of the remand of the McCutchen case was that they were looking at the wrong documents. Per the U.S. Supreme Court case Cigna v. Amara, the summary plan description is not the governing plan document. The master plan document is. So this is the SPD versus MPD argument. Most subrogation vendors and even in-house subrogation departments will only produce the SPD. And this is the document that's updated yearly and can continually close any gaps that created obstacles from the year before. This is also often usually created by the insurance carrier that's administering the claims versus being created by the employer itself, like the master plan document is. So the key is to review the MPD, the master plan. It may be that it has a lot more limitations, and I see a lot of attorneys not requesting this document and starting to negotiate with the wrong document, with the document that's produced by the subrogation vendor or person representing the lien holder. And that document is no doubt usually stronger for the health plan. So just as a little caveat though, the SPD can sometimes be incorporated by reference into the MPD, but that's often something that's missed. So under the ERISA statute, a plan participant is entitled to documents. You must request them from the plan administrator. That's the employer, not the insurance carrier, not the subrogation vendor. Now, a lot of these subrogation vendors don't like for you to go to the employer, but that's exactly what the ERISA statute requires the plan participant to do. And then you'll have other subrogation vendors who will completely refer you to the employer and say that they don't have the documents. So that's often something that you'll hear is that we don't have everything that you're asking for under the ERISA statute. We're not the obligated party. Go to the employer. And along with that, there is a penalty for the employer for not complying with the document request, which is we call internally the 1024B4 because it is that section of the ERISA statute, and I've got some of those cites there. There is a penalty that is $110 a day for the plan administrator lack of compliance with producing the documents within 30 days. Now, one thing you'll probably hear is the subrogation vendors saying that they themselves are not subject to the penalty, and as such will not want to subtract from their lien because of the penalty. But again, this is just a side shifting. I mean, they are representing the interest of the employer, and it is the employer who is subject to the penalty. So it all should be part of the negotiations. I am going to talk briefly about the Form 5500 to bring it back to where those statistics came from at the beginning of the presentation. I wrote about this in the blog that accompanies this month's Thursday webinar, so you should have received an email about that, but you can also locate it on our website under resources. So it may be easier to review in writing, but I'm going to talk through it generally here. So this section is the first place that you should be looking on the Form 5500 once you get it pulled up. I've got two website addresses there where you can find the Form 5500 on your own. You can certainly ask the plan administrator for one, and you can also ask the subrogation vendor for one. You may or may not get it from those sources, but these two websites should get you one if one exists. So this section here, section 8 and 9, are the important places that you want to look. When I was on the other side, I saw many attorneys stop here at section 9 and present their arguments that the plan was not self-funded, that it was insurance. And when they did that, I knew I was going to win the argument. So here you see that the box for insurance and the box for general assets of the sponsor is checked. And all this means is that of all the benefit plans provided by the employer, there are some that are fully insured and there are some that are self-funded. So you can't assume that the health plan is insured just because the box is checked. That's where you've got to look at Section 8 that's right above there. Section B is for the welfare benefit plans, and it lists all of these codes for A, B, D, E, F, going through the alphabet, and that is indicating which of the benefits is falling into those boxes. So as you can see, there's 7 benefit plans that encompass 2 boxes. You can't by this on its own make that determination. So from there, you want to look at the schedules. And Schedule A that accompanies the Form 5500 lists the insured coverages, where Schedule C lists the self-funded ones. And I must say that unfortunately, even with an 82-page instruction guide that I found as I was creating this, these forms are often completed incorrectly or incompletely, which makes them often unreliable for determining funding status. But if that's the case, it certainly can be a negotiating point if you're finding inconsistencies. So sometimes here also with the box 9, you'll only see the insurance box checked. Then you can make the argument that health insurance is an insured benefit. There'll be other times where you see only trust or general assets of the sponsor, and in that case, it's more confirmed that every benefit is self-funded. So just some things to look at when you're looking at the Form 5500, but definitely just recommending that you make as full of an argument as possible and not step off on the wrong foot, because when you do, it'll give a win to the subrogation vendor. And the last slide I want to share here today is just a recent win that Team Synergy had on a self-funded lien. So this particular lien came from a Pennsylvania law firm. The lien was asserted at about $312,000. The case settled for $1 million. This was a failure to diagnose case. And as easy as they should be when it comes to dealing with liens, it's common for these ERISA lien holders to hold on to their asserted right to collect until the bitter end. Big conversations have to be had about treatment that would have been required anyway and what was attributed to the failure to timely diagnose versus just part of the medical condition. This particular case had some language issues that we were able to capitalize on, and also some issues with whether or not the self-funded employer was still in business. So after arguing the facts of the case, the deficiencies in the plan language, and the other negotiating points, the Synergy specialist that handled this lien was able to get it reduced to $25,000. So this was a huge win for the injured party, and certainly something that Synergy celebrated. And that does conclude the presentation. So we're going to go ahead and move into the question and answer section. It does look like we've received a couple questions throughout the presentation. My email address is listed here. You can certainly send me any email with any questions and I will answer it or route it to somebody on my team or get you in touch with someone who can assist. So please do take note of that. Let's see. The first question I see is, where an ERISA plan will reduce for attorney's fees and costs, can we request a reduction for out-of-pocket expenses, co-pays, from an ERISA plan? Well, my first thought is you can request anything that you want. I think the real question is, do they have to take it into consideration? And it's really going to depend on that policy language. So I'm assuming if they are reducing for attorney's fees and costs, then maybe it's because the policy itself says that they have to, or maybe it's because it's silent altogether and you've successfully argued that they're going to have to reduce for attorney's fees because they didn't contract around it. Same can be said for out-of-pocket expenses. There's not really any case law or anything that's confirming out there that an ERISA self-funded plan has to reduce for out-of-pocket or co-pays, but sometimes those subrogation vendors will take these kind of things into consideration as part of their negotiating. So the big answer is no, it's not absolutely something that they have to do, but it's certainly something you can request. And another question I've got here is, if the settlement is strictly are they allowed to recover benefits paid? And that's going to go back to the policy language. So these ERISA self-funded claims are governed by their policy language. You're going to want to look to see who they actually name as a recoverable source. So if it does say that they can recover from a UIM or a settlement, then yes, unfortunately, they are able to collect from that settlement fund. Next one is, you mentioned the plan administrator. Where do I find that information? How do I identify the plan administrator? So the plan administrator is the employer. So if it is an ERISA plan, it's an employer plan, and plan administrator, obviously if it's a really big company, it might be hard to get to the right place, but you should find that information on the Form 5500. So the last couple slides there that we just looked at, there is a section where there will be contact information for that person. Alternatively, if you're dealing with a subrogation vendor, if you're already in contact with somebody, you can ask them for the policy language as they have it. They'll send it to you, and it's usually towards the back of that entire policy language. And you can find that information as well. If it's not in there, that's a problem, but certainly ask the subrogation vendor or look on the Form 5500 to find that information. Another question, should we try to negotiate a self-funded ERISA claim at the beginning before we file suit? So that's definitely a strategy question. I don't know that a self-funded ERISA plan will readily negotiate prior to a settlement. So there are certain situations where there really does need to be a little bit more of a firm number as it relates to the lien. But depending upon the case facts, I mean, if that policy language is really problematic and you're able to find things in it to point out, then you certainly, before you settle the case, can say, you don't even have a right to be at my table at all. So send me your closure letter. So that type of negotiating can take place. But as far as really trying to get them to agree on their $100,000 lien to take $50,000 before you've settled the case or before you've even filed suit, when that's your intention is to litigate it, it probably would be difficult. They probably wouldn't do it. All right, let's see. Federal employee has not been notified of any lien in the auto crash. Blue Cross Blue Shield, what obligation do they have for notification? And then there's a second part to this question. So for that one, so it says federal employee. So I'm assuming that this would not be an ERISA lien, but instead a FEBA lien, which is for federal employees. But regardless, whether it's a FEBA lien or an ERISA lien, both likely have inside that policy language a line or two that says that the plan participant has a duty, an obligation to report that there's a third-party liability possibility to the insurer. So that question did come in a little earlier, and I was able to find in a policy language I actually had pulled up on my computer here. So I'm just going to read it to you so that you can know what to look for. So this particular one just says, if you do seek damages for your illness or injury, you must tell us promptly that you have made a claim against another party for a condition that we have paid or may pay benefits for, and you must seek recovery for our benefit payment and liabilities, and you must tell us about any recoveries you obtain, whether in or out of court. So obviously, that's them CYAing and trying to make sure that they pass that duty on to the injured party. But that's what they're going to refer to, and could consider it a breach of contract if the notification is not made to them. Second part of this question is, what is the statute of limitation for government insurer to claim any benefits which may have been released to claimant? So the statute of limitations for ERISA plans, FEBA plans similarly, not super clear. So there's not, and really, because it's not super clear, everyone has their own interpretation of what that is. But because both of those are, and we're going to just focus on ERISA, but because an ERISA plan is governed by its policy language, it's therefore a contractual right. And so it's going to be the contracts statute of limitations in that state. Alternative argument could be in the circuit, but most of the subrogation vendors will go by the state statute of limitations for contracts. All right, another question. If Cigna, on behalf of the self-funded ERISA plan, communicates directly with the liability carrier, can they disclose the amount of the claimed lien without violating the client's privacy rights? So that was what I talked about a little bit earlier as far as subrogation, and particularly the difference between subrogation and reimbursement. This is a valid, like, identified issue of, hey, aren't they violating HIPAA by providing my client's claim information to some outside party? I could tell you that when I worked on the other side, I got that argument a lot, and we had a default answer. And basically, the default answer that you're going to hear is that the policy language of the ERISA self-funded plan grants them a subrogation right, and they're a business associate of the health plan, and the health plan has a direct cause of action or a direct right of subrogation, and then by default, they are allowed to release that information. Ultimately, though, it's an undeveloped area of case law, and so because it's gray, those subrogation vendors push that envelope. All right, and I do see the list of questions are just stacking up, so I do apologize. I don't think I'll be able to get to all of them. I'm going to keep plugging away here, but if not, please do know that we'll reach out to you separately. Okay, so it says here, let's see. It says, what are we looking for under the Form 5500, 8B? Yeah, so under 8B, that's the one where it says 4A, 4B, 4C. That's telling you, and that's what on that slide I have the key on the other side that tells you what each of those letters stand for. And so it's basically all of the benefit plans that the employer provides. So you're often going to see a health insurance as 4A, you're going to see dental, life insurance, disability insurance, all of those different kind of things. And really what that's telling you is you can't look at 7 different options under Section 8 and make any assumptions on what boxes 9 mean, because it could be that the health insurance is self-funded, and that's why the general assets of the sponsor is checked in box 9, but then the dental is fully insured, and that's why the box for insurance is checked in box 9. So I was just trying to point out that that's where some important information can be seen. If you have further questions about that, though, feel free to reach out. More than happy to discuss further and look at your particular case. Another question, any case cites that self-funded ERISA liens should fail if the plan is no longer operating or the employer is out of business, such that the lien recovery cannot be returned to the pot? Honestly, on that case that I just used as the example where that was an issue, we did some digging and I didn't find anything that was super clear to make that argument, which is why $25,000 was ultimately paid out on that versus 0. But I do feel like there should be something out there, but as you see when you start to dig in on this ERISA self-funded stuff, there's so much that is just not established in case law, so much of that gray area that we all just then have to operate in. Next question, what if the plan is funded by insurance and trust? Both are checked on the 5500. Are they self-funded? That's similar to what I was just saying. That's why you've got to look to the box 8 to see what it is that it's trying to refer to. The next step, though, is to look at the schedules. So Schedule A and Schedule C. Schedule A is going to show you the fully insured benefits. Schedule C should show you the self-funded ones. Another question, are all union plans ERISA plans? As far as I know, yes. Next question, does the employer usually have the right under the plan to waive its subro claim? It's an interesting question. So there is usually wording in the policy language that talks about who has the discretion or who has the authority to interpret the terms of the plan. So sometimes it's in the subrogation section itself, and sometimes it's just elsewhere in the 100, 200 page document. So definitely something to look at, because sometimes we do find that it says that it's the employer that has that right, which means that if you're talking to Optum, they don't have the right. And if you're talking to an in-house at Blue Cross Blue Shield, they don't have the right because it says that Wells Fargo has the right, whatever the case may be. So definitely a good issue spot and something you should look for. Next question, how do you know the difference between the SPD and the MPD? So the SPD usually calls itself that. It'll usually call itself the summary plan description. The MPD is usually more of a legal document. So when you see the two side by side, you can see that the SPD is the summary and the more layman's term version, and the MPD might be in outline form or have articles or things like that. And not always, but that's definitely one way that they can fully stand out. Also important to read the first couple pages of both plan documents. So don't just jump right to the subrogation section, because that's where it's going to say whether it's the summary or whether it is the plan document and which document controls when there's a conflict and all of that kind of stuff. All right, I see we are not going to have enough time to completely finish, and the list of questions keeps going, but I'm going to end here on this last one. It says, does Synergy have a fee schedule? If not, how does the fee at Synergy work? And yes, we do have a pricing sheet, but it's pretty basic. Our fee is 15% of savings. So whatever it is that we're able to get reduced off the lien, our fee is 15% of that. We do have a cap, though, for cases that have limited settlements or that have lots of liens that end up needing to be paid. And that cap is that we will take as our fee no more than 15% of the net that goes to the injured party after attorney's fees and liens and all of those things are paid. We do have a $250 administrative fee for certain services. So that's for any traditional Medicare is going to be a $250 kind of beginning rate. Liens that are smaller, so under $5,000, settlements that are smaller, that are under $25,000, and there's one more that I can't remember. You would think I would know that. Sorry, my mind just went blank, but we do have the fee schedule. Feel free to reach out. You can send the email to me or to marketing, which any of the emails that you receive, you should be able to reply, and you'll get right to marketing and they'll send you over to the right place. But yes, we do have a fee schedule document to send over to you. All right, I'm going to go ahead and wrap up. It looks like we got 1 minute until the end. I do see some other questions, though, so I will be reviewing those here and making further outreach. But thank you for joining us. I hope you learned a little something, or at least got your mind thinking of some other arguments that you can make when you're dealing with these. Otherwise, if you want to involve Synergy, I've got my team here and we're ready to help. So feel free to reach out. Our contact information is listed there. I thank you for your time.